Hello and welcome to the Arbitration Conversation. So in this episode, we have the pleasure of Professor Jill I. Gross. Professor Gross is a real expert in securities arbitration, which is great because we have not yet touched securities arbitration as part of the arbitration conversation. So this will be great. She's also the Associate Dean as well as a Professor of Law at the Pace Law School. And she is the author of a book, The Broker-Dealer Law and Regulation, and extensively writes many articles on securities with arbitration, negotiation, mediation. Thank you, Jill, for being here.
Oh, thank you so much for having me. I'm pleased to join the conversation.
Well, this is good because FINRA. So if you could just give a little bit of background for those that aren't really familiar with how FINRA, what is FINRA and how does FINRA arbitration work?
Okay, so FINRA is what is known as a self-regulatory organization in the securities industry. Since the industry is heavily regulated, every activity of any securities industry participant is regulated, including arbitration of disputes. And so the Securities and Exchange Commission oversees FINRA. FINRA operates the largest dispute resolution forum in the securities industry, and they hear 99% of all securities-related disputes. Many of those disputes arise and head to arbitration because most broker-dealers have arbitration clauses in their customer agreements. And even if they don't, the securities industry has a rule that a customer has the right to go to arbitration upon its demand. They don't even have to have a pre-dispute agreement. So many disputes end up in arbitration that are between a customer of a brokerage firm and the brokerage firm or its brokers, and also intra-industry disputes, disputes between, say, a firm and an employee about something that arose during the scope of their employment. So those are the most common kinds of disputes, and they end up in securities arbitration.
Wow, it's interesting. I didn't even think about that or realize that employment claims could also end up at FINRA.
Oh yeah, actually now the breakdown in the FINRA docket is about, it's been trending towards more intra-industry disputes. So it used to be like 60-30, 60% customer disputes, 30% intra-industry. Now the latest ratio is 55% customer disputes, 45% intra-industry. And many of those, and the reason for the rise in the intra-industry side is what we call promissory note disputes, which are employment disputes between a brokerage firm and its broker that's usually hired in a system where they get advanced payment to join, and then they pay it back over time with a promissory note. And then also expungement cases where the broker seeks to get his or her record expunged, and they need to do it through the arbitration process. And so there are employment disputes as well, although FINRA has a rule that you can't require sort of sexual harassment claims to be brought in arbitration unless there's an explicit pre-dispute agreement and there's a carve out, and so it's complicated. But yeah, so it is some employment disputes.
So it's very active, I would assume, many claims each year. So how does it normally work if we weren't in the middle of a pandemic? Where do these in-person or where do the hearings take place generally?
So the hearings, the FINRA hears about 3,500, well, it gets about 3,500 cases a year are filed. They have a sort of a fairly typical arbitration process where there's a statement of claim filed, an answer, then there's arbitrator selection, which is through a neutral list selection system, a randomly generated lists based on the type of dispute and the type of qualified arbitrator. There's discovery, there's very limited motion practice. And then there's hearings, and they typically happen within about a year. 12 to 14 months is around the turnaround time. 15 months is the average from filing to award. And so they have hearings. The hearings are based on the residence of the claimant. So if you're a New York-based customer, then your hearing would be in New York. If you're a Missouri-based customer, your hearing would be in Missouri. FINRA has regional offices in 4 big cities in the various regions in the country, but then they'll also rent hearing space at, say, a conference center or a hotel or wherever. So they want to make sure that customers don't have to travel far for their hearing. And then the hearing takes place, either a 1 arbitrator or a 3 arbitrator panel, depending on the size of the claim, an award. There's a strong sort of weapon that customers have or claimants have, because FINRA requires the award to be paid within 30 days, or else the firm, if it's a firm or registered representative, would lose their license if they didn't pay the award. So there's benefits to being in a regulated industry with arbitration. You have almost a guarantee, unless the firm goes out of business or declares bankruptcy, that you're going to get paid on an award if you get one.
That's actually really important, though. That's great, because otherwise you don't have to worry about collection on judgments very often, I would assume. So right. That's pretty great.
Yeah, there's only one exception, which would be if they made a motion to vacate the award within that 30 days, then that tolls the time.
So given that that's the usual process, and now we're, of course, in the middle of this pandemic, I was really curious to kind of hear your thoughts on how things have transitioned or not transitioned, and maybe share a little bit about what happened and how FINRA decided to stall processes in person but allow for virtual or telephonic.
So FINRA, when the COVID crisis erupted, FINRA halted all in-person hearings, both for arbitration and mediation. They administratively postponed them first through, I believe, July, and then just recently they issued an extension of that postponement through the beginning of October. And the order is that all hearings that were scheduled are adjourned administratively, unless either the parties agree to proceed virtually or via telephone, or the arbitrators order the parties to proceed telephonically or via Zoom. And they said they'll resume October 5th if necessary. We'll see whether they extend that adjournment again. They also offered parties to waive all adjournment fees if for hearings that are supposed to take place between October 5th and the end of the year. If the parties want to adjourn those, they'll waive any adjournment fees for that adjournment. They say all other case activities are proceeding with the same deadline, so discovery will go forward, arbitrator selection, any motions that might be filed, which again are very limited in FINRA arbitration. So all those other case deadlines stay in place, but hearings are adjourned. There'll be no in-person hearings at all until.
So I wonder how many, or what you've seen or heard, how many individuals or how many parties, firms, customers are deciding to go online to actually do a virtual Zoom hearing?
So I only know anecdotally that, and I don't think this has been reported by FINRA, that I think that most hearings are not going forward. It's always in a respondent's interest to postpone or delay. So I don't see why they would agree to go forward virtually when the alternative is putting it off. I can imagine an arbitrator or a panel ordering it to go forward virtually if it's already been the subject of many, many delays and they want to go forward. But given how serious the pandemic is and how uncertain the situation is from state to state, I find it hard to believe that any arbitrator will really force a party to go forward with a hearing unless there are extenuating circumstances. So my sense is that very, very few have gone forward on Zoom.
Well, and I suppose it's kind of a dangerous gamble, right? I know the NAA, National Arbitration Association, they also, they did have an allowance for arbitrators to order that a hearing go forward even over the objection of a party. But I would imagine that there's some dangers in ordering it over a party's objection.
I mean, certainly, you know, when you agree to arbitration, and certainly when these parties agreed to arbitrate disputes, it was arbitrating it with a hearing in person. Mm-hmm. And now you're sort of after the fact taking that feature away. I have advocated that, there's no replacement for an in-person hearing, that in order to get procedural justice, to feel that you've been heard, that certainly a telephonic hearing is not sufficient when you're dealing with issues of credibility, which you're often dealing with in customer disputes. The broker promised me this and delivered, promised me X, delivered Y. The broker promised me my money would double overnight. It didn't, I lost. That those are really issues of credibility, and you want to see the witnesses in person, see their body language, not see just, them from the waist up or even less. So I think from a procedural justice standpoint, it's arguable that you're really taking away from the sense of justice when you have to go forward with a hearing on Zoom. On the other hand, I would say I had been teaching remotely since March. I plan to teach half and half in the fall. And I think it's pretty comparable to in person. It's not ideal, but it's comparable. So is there that much justice taken away? I'm not as convinced as I would have been if you had asked me in March.
I love this discussion because I agree with that. I mean, if it were just telephone, right, that's very different from, and if it were Skype from 10 years ago, that would be different as well. Right. I mean, it's just what we now have as far as the technology is so much more advanced than what we used to have. It kind of really changes things.
Yeah, I mean, the advances in technology have really enabled us to do things in the law, including arbitration, in ways that no one could have predicted a while ago. Although maybe people like you predicted it, since you're so involved in technology-assisted dispute resolution.
But I will say this, though. I actually do feel very strongly. I think it's very important, though, that all parties involved have equal access to the technology, equal understanding of it, equal comfort with it. So those are some issues that often come into play in, I'm sure, cases for FINRA as well. I mean, it's very different if you're a broker with a fancy computer and the whole setup and a wonderful camera versus maybe a customer that's they don't really have a computer setup. In fact, they might even be on a mobile device. And so that kind of really means it's not a level playing field.
That's right. And when you have customers who the reason they're filing arbitration sometimes is they've lost their life savings because of alleged misconduct by a broker or a firm or both, they may not have internet access or reliable access. They may not be able to hire a lawyer. They may not be familiar with the technology. These are retirement accounts, retirement assets. So, mom and pops, so there is not a level playing field when you talk about those kinds of disputes. Other kinds are more level. So it does vary.
Well, I think it's going to be interesting to see what new cases start coming out. I'm sure there's going to be lots of new claims after all of this having to do with people's retirements and maybe how things were handled during all of this, especially with different changes in the law over time.
Yeah, and you also had at the beginning of the pandemic a massive stock market drop. So there were a lot of losses that may not have been realized at the time, but there were losses incurred by some people who were stunned at how quickly their accounts could go down. The market's recovered quite a bit since then, but if somebody got nervous and sold out in March to try to mitigate their losses, then they have a real claim that stems directly from the pandemic and would then end up in FINRA arbitration and now not be able to schedule a hearing for, who knows when.
Right, and I have to say, I think the bumpy ride is not over. I'm pretty convinced of that, but we'll see how it goes.
Yeah, you and me and the crystal ball, so.
Right. Well, listen, Jill, this has been great. Thank you so much for taking time with us, and this is really
it's my pleasure.
Stuff. So many more questions. Maybe I'll have to have you on again because I can already think of a bunch more. So thank you so much for taking time with us today.
My pleasure, Amy.